The Maxwell School for Public Affairs has been ranked top in the nation for years in postgrad academics, but according to international politics PhD candidate Mary McLaughlin and other employees, it's recently been lacking in academic freedom.
I do not feel like I can in good conscience tell my students to act in favor of their moral beliefs if I know that they'll be punished, threatened, and intimidated.
4 months ago, just outside Maxwell, on SU's quad was where the organized encampment in support of Palestine was held. Mary supported from the sidelines.
I am kind of a coward and did not want to get punished.
But after seeing nationwide violence rise, Mary decided to register through the National Lawyers Guild. Their job then became to attend, observe, and report any violations of the First Amendment. And that's when the accusations started.
Being treated like a criminal, right? Being told I have an incentive to lie, it was clear that that was a really hostile treatment.
Mary received an email a month after observing the encampment the day they were ordered to disband. It accused them of violating the code of conduct on May 9th. They would have to go through SU's formal disciplinary process.
Evidence. It was super uncomfortable to share with my employer. I went on a Tinder date and had to send them screenshots of my Tinder date. Everyone I went to the bars, right? I just did not want to have to account for a 4-day span to my employers, but did.
VP of Student Engagement Kyle Daly reported seeing Mary participating in the encampment, but would later admit in their hearing that he did not witness them. Instead was referred by another that Mary was there, and had the wrong date of the accusation up until halfway through the hearing itself. This would be hearsay, misuse of, and unsubstantial evidence, which would likely result in a mistrial. But instances of the university using the disciplinary process to mislead students to a guilty verdict isn't something that's new. And these cases made headlines. Melissa Swartz is an attorney who represented star SU running back LaQuint Allen in both his criminal and university cases, and says that in her experience, the process has room for improvement.
Allows for a student to have a procedural advisor that is either a faculty, student, basically a member of Syracuse University. I do not think that the way the disciplinary system is set up right now is a fair process for students, no.
She's in agreement with a professor at SU Law School, Gregory Germain, who has been pleading for the university to create a more fair system since a change over a decade ago.
When the proposal came to the law school, many of us were very concerned that we were undermining the kind of judicial system that we have in the United States.
The law school rejected the idea of student self-representation, which the university conveys is a learning opportunity for those accused.
Well, I don't think they're learning anything positive from going through an unfair hearing process. I mean, other than to feel like, to hate the school.
Germain would reach out to the Department of Education, who would get involved in some cases, but ultimately decided to allow SU and other private universities to hold their policies. But there have been some recent changes.
I think it's very important, if you have a criminal case pending with your disciplinary case, that you have an attorney with you.
That's no longer the case. Just months after representing Allen in front of a judge and the university, SU no longer allowed for attorneys to be present in any non-Title IX case.
In terms of being at the hearing, I mean, it's horrible, right? Because I'm watching a student represent themselves against something serious.
The I-Team reached out to the community standards and those who accuse students like Mary of violating their policies, but they said federal law prohibits them from speaking on any case, and that any questions regarding their policies can be found on their website. The I-Team looked in and reached out to multiple private universities across the state to see if these guidelines were common, NYU and Columbia both allowing outside counsel in all conduct hearings, Rochester and Fordham adopting the same rules as Syracuse, barring the most recent change. But with no rule change in sight, Germain says there's only one thing students can do besides hiring a lawyer to fix the rights to academic freedom on campus.
Listen to arguments from all sides and to think independently and to accept other people's point of views. To a university that is dominated by very angry, loud students who have a particular point of view and don't want to hear any arguments to the contrary. And that's on both sides of issues. It's not one-sided. And so it's become kind of a violent atmosphere that I think is very detrimental to the learning process.
He urges those to look to the stances of opposing views with compassion, so students like Mary don't face threats of expulsion and termination for trying to keep the public safe. In Syracuse, Luke Welch, CitrusTV News.